I'm Chris Drahozal. I'm the John M. Rounds Professor of Law at the University of Kansas, and I am the chair of the Consumer Arbitration Task Force at the Searle Civil Justice Institute. In our preliminary report that we issued in March, we examined in detail the administration of consumer arbitrations by the American Arbitration Association and looked at things like who won in the cases, how much they won, how long the process took, as well as how well the AAA or how the AAA administered its consumer due process protocol, which are basically private fairness standards in arbitration. And what we found was, in the latter category at least, that basically the AAA did what it said it was doing. In the vast majority of cases, it applied the protocol properly, and that in a lot of cases businesses would then either change their practices or change their arbitration clause to comply with the protocol. The research now is moving on to comparing, or trying to compare, the arbitration cases we looked at before, as well as some other arbitration cases, to similar cases in court. And it's not an easy thing to do. There's always differences among court cases. So to try to make them as comparable as possible, we focused on a narrower subcategory of cases, which are debt collection cases, cases where creditors are trying to recover amounts allegedly owed by consumers. And there's still differences among the cases, but at least the basic issues in the cases are largely the same. They're going to be was the amount owed and was the amount paid, and then possibly some defenses like the statute of limitations. So as a basic matter, the cases are at least roughly comparable. And so what we looked at for this phase of the project was, again, the AAA cases, the American Arbitration Association cases that we started with, as well as another group of American Arbitration Association debt collection arbitrations that were brought by a single debt buyer and handled in an online fashion and so forth. And compared those to debt collection cases brought in court. And we used a sample of Oklahoma cases because there's good online availability of data in Oklahoma. We also looked at some Virginia cases where we had access to an existing data set. And then we looked at student loan collection cases in federal court, which is one of the rare examples of a collection action being brought in federal court. And the ultimate question we're interested in is what can you tell about the fairness of arbitration by how well businesses fare in arbitration? There's been a lot of suggestions in the public policy arena that we can tell arbitration is unfair because businesses win 90% plus of the time. And that's all. That's all we need to tell whether arbitration is unfair. And I just don't think that's right. That I think to have any evaluation of arbitration, what we need to do is compare it to litigation. And so what we tried to do in the next phase of the study was to the best of our ability to do that. What we found in the second phase of the project was that certainly in arbitration, in these debt collection cases, businesses do in fact win a high percentage of the time. In the cases in our sample, the creditor won some amount in from 86 to 97% of the cases. However, when you look at the roughly comparable cases in court, it actually turns out that businesses win a higher percentage of the time. In the cases that go to judgment in federal court, for example, creditors, U.S. government, recovering student loan debts wins over 99% of the time. In the Oklahoma small claims cases we looked at, the creditor won every case, 100% of the cases that went to judgment. Now, we don't certainly suggest that that means arbitration is better for consumers. There's still no doubt are differences among the cases that we can't control for. Although, frankly, even when we do some regression analysis and control for things like the amount at stake, the type of debt that was raised, whether the consumer shows up, things like that, the results are similar, that in fact the creditor win rate is lower in arbitration than in court. But again, we don't suggest that means arbitration is better. It certainly, though, shows that you can't evaluate the fairness of arbitration simply by looking at the win rate of businesses in arbitration, because by that standard, court systems are even worse, because the win rates of creditors, defined exactly the same way as we did for arbitration, are even higher than they are in arbitration. When you look at the percent that creditors recover in court, it's similar, not quite as stark versus arbitration. It's similar, but not as stark, because again, you have creditors recovering a very high percentage of what they're seeking in arbitration, but the numbers in court are very similar. And so again, there's certainly no evidence based on the outcomes data that's out there that suggests that arbitration is in some way biased in favor of businesses and against consumers. At a minimum, the results of the second phase of our study show that you can't evaluate the fairness of arbitration simply by looking at the percentage of cases that businesses win in arbitration or how much they recover in those cases. You have to compare it to court. And once you do that comparison, you see that arbitration isn't all that different.